what we're doing in this election, I think we're kind of stuck with the candidates that we're stuck with. We want to make a statement as best we can with the candidates that are going to be like Sean Crowell, and in my case, on this U.S. Senate, Danny Page, because although we know the other guys are going to win, the stronger their victory, the worse it's going to be for us. We need to make that statement by voting for people who have principle to fill the positions. But this election isn't really, I don't think, as much about people and who are going to be representing us as it is about these resolutions. And I want to get that started by talking about what is a resolution and why is it important. And you're the Constitution Party, so you above everybody else should know this. It all starts with a foundation for our country. And the foundation for our country, besides the people themselves, is the United States Constitution, and under that, the state constitution. So I want to take just a moment to say what a constitution is and why it's so critical. I have a quote from Patrick Henry, and what he said was, "A constitution is not the act of a government, but of a people constituting a government. And government without a constitution is power without a right. All power exercised over a nation must have some beginning. It must be either delegated, which means given, or assumed, which means taken. There are not other sources. All delegated power is trust, and all assumed power is usurpation. Time does not alter the nature and quality of either." So what he's saying there is that before a government can exist, some power has to be put in the hands of people who are governed. Now, if we put the power in their hands, that is the kind where trust has established the government. If people take power themselves, that isn't trust anymore, it's tyranny. Now, the foundation for all the power that they exert, those people who are governing us, is in the United States form, a constitution. In other nations, in other types of government, a tyrant makes his own rules. They can vary from day to day, and so on. But within our government, the Constitution is the source of all power. And I want you to think about, where does the source of power come from, and where is it stated in our Constitution? What are the first three words of the United States Constitution? All right, see, that is the declaration of who the authority is coming from on the power that created this whole nation. It was we the people. Now, it wasn't so much that we wrote the individual words for the Constitution, but when the people who drafted it came up with it, they submitted it not to the state legislatures, but to conventions of the people within each of the prospective states. And those people are the ones who ratified our Constitution. So it genuinely was the United States people, the people of Virginia, the people of Massachusetts, and so on, who said, this will be something on behalf of me, I will have our state accept, and we will become part of this new union. That's the authority. Now, in there that lists the structure of the government with the legislature and the executive branch and the judicial branch and so on. And in the legislative branch, it gives us the powers that this government could exert for it. And it's real important to look at those enumerated powers. I'm not going to do all that tonight, but I want to tell you one thing about that. If you give a list of powers, you're empowering, but you're also limiting. Because if it's not on the list, it's not something they can do. And the example I like to give is, let's say you've got your grandkids over, otherwise I'd say just kids, and you say, all right, John, you've got the toy box over here, and today you can play with the G.I. Joe and the Legos, but you know there's also a beach ball in there and a bat. By saying you can play with the G.I. Joe and the Legos, you are also saying you cannot play with the beach ball and the bat. And that's what the 10th Amendment's all about. So what are the powers that come to the states? Well, the states each have their constitutions. And how many of you are familiar with the beginning of the Tennessee Constitution?
I've got it right here.
All right? What I could do is ask you to read Article 1, Section 1, and Section 2. And this Tennessee's Constitution was stated by Thomas Jefferson as the least imperfect constitution of all the states when our state was founded in 1796. Have you got that there?
Is it Article 1, Section 1?
Article 1, Section 1 and 2.
Okay. That all power is inherent to the people and all free governments are founded on their authority and instituted for their peace, safety, happiness. For the advancement of those ends, they have at all times an unamiable and
Indefeasible.
Thank you. Right to alter, reform, or abolish the government in such manner as they might think proper. Section 2 says that government being instituted for the common benefit, the doctrine of non-resistance against arbitrary power and oppression is absurd, lavish, and destructive of the good and happiness of mankind.
Slavish.
Okay.
And so how does our state constitution starts with this rebellious posturing that no matter what we might stick up there, we have, and however it may get torn away from us, we have the right to alter, reform, or abolish it. Because it's our government. All the Constitution of the United States belongs to the people, not the Supreme Court, none of the other branches. They are our agents for managing it. And the same thing with the state constitution. So when you look at the amendments that are on the ballot this time, what you are looking at is your authority to define the parameters within which our assembly will work. That's really very important. You're setting the rule for no matter who gets elected, they got to stay within this fence. So what we want to do is we want to look at exactly how amendments are made and how we got to where we are. For an amendment to get on on the ballot this year, there has to have been 2 terms of the assembly. The first term, both the House and the Senate agreed by a simple majority to propose this resolution. Okay, let's say it's Amendment 1. And those words were passed several years ago. Then they have to put it on the table and wait for an election to occur. So if the people don't like what was proposed as an amendment, and their legislator, their state rep or their senator, was one of the ones sponsoring this thing that they found offensive, they could have one chance to vote that person out and replace it with somebody, because it's going to come back into the assembly again. All right? And then the second time it comes through the assembly, it's got to be a supermajority vote, 2/3. Okay? Those things have happened to all 4 of these amendments. And that's why they come to the final authority in the state, you. So what are the amendments? You guys have already gone over it pretty well, I'm pretty sure, just from the discussion we already had, but I'm going to review some parts of it. I got a summary of them right here. And what I'll do is I'll go ahead and pass these out now. I've got 20 copies, and so Mickey doesn't get one, but there's, I think, enough for everybody else.
And plus, if you would like the already picked version, you can have that too.
I think this is the way I've written it. This is the way I've written it, and so there's some commentary that's exclusive to me. But the First Amendment is, shall Article 1 of the Constitution, and I'm not going to read the whole thing, but just get the gist of it, be amended by adding the following language as a new appropriately designated section. Okay, so this will be some new section in the Constitution that doesn't previously have a number, all right? It will say, nothing in this Constitution secures or protects a right to abortion or requires the funding of an abortion. The people retain the right through their elected state representatives and state senators to enact, amend, or repeal statutes regarding abortion, including but not limited to the circumstances of pregnancy resulting from rape or incest, or when necessary to save the life of the mother. Now, this thing came about because of the Tennessee Supreme Court. And what the Tennessee Supreme Court did in the year 2000 was it got a case challenging the statutes that the Assembly had passed that said you got to inform the mother of just exactly what an abortion is. You got to give her 2 days to decide if she really wants to go ahead with it. You got to have a facility that is an inspected medical facility and so on. Just some very simple things that are for prudence and safety. Those conformed to the authority that they gave in Roe v. Wade from the federal level. States were prohibited from prohibiting abortions, but they were allowed to have reasonable, non-burdensome restraints that made it a little bit more prudent if you're going to go ahead and have an abortion. But what the Tennessee Supreme Court did was they looked at a variety of sections of the Tennessee Constitution, and it got a little complicated, but they didn't really specify how those sections of the Constitution gave these extra rights that they then constructed that said, okay, there is no way that the Tennessee legislature can restrict abortions because the right to privacy in Tennessee is greater than it is in the federal Constitution, and it is greater in such a way that abortions cannot be restrained. You can do it anytime, anywhere. And so Tennessee, unlike the states around us, which are conforming to the Roe v. Wade limitations, Tennessee's limitations were nothing that the state could slow down the abortion with. And they're coming this way.
I missed the date that they did this.
The year 2000 is when the case was, and I'd have to, it was...
Well, I don't need the exact date.
Okay.
Thank you.
Yeah. So, that was 14 years ago. And finally, it's getting to the point where Tennessee has statistically been demonstrated to be a place where people come when their own state is going to slow them down a little before they kill the child. That is inappropriate. It was something that the Tennessee Supreme Court did that everybody was startled about, in this invention of a greater barrier against restraints. And so what we wanted to do, or what we as a state want to do, is to put this slight limitation on there to say that the constitutional interpretation that the court made back then is simply not valid, and it does not represent the interests of the people who own this Constitution. It will not overrule Roe v. Wade. No. All right? All it is going to do is say there can be some prudent restraints and medical safeguards on abortions. The Assembly has the authority to pass them under the will of the people. And it will be limited to roughly the same sort of thing that the other states around us are limited to doing. Now, when you see these advertisements against Amendment 1 on television with that lady from, what was it, Vanderbilt, who is lying through her teeth, it's not going to empower the legislature to intrude on whether you do it or not. It's going to only be what steps you go through to get there. And they can't be overly burdensome. Roe v. Wade prevents that. It's not going to affect your rights in marriage. It's not going to prevent protection of the mother's life if it's a baby or mother situation. The Assembly can't do that. This is strictly to overcome what I consider renegade Supreme Court came down with inventing ways to enable abortions. All right? That's the bottom line as I see it on Amendment 1.
It won't do away with abortion.
Oh, no, it
will
can't.
make it safer for the mother
It'll make her think once before she
And it'll
goes
make her
to,
think.
yeah.
And it will also, juvenile has to go through the parent with consent, right?
Parental, well, see, that's the thing. It could do that. This is not going to pass the laws. This is simply going to say the assembly can pass the laws. Then it's up to us to guide our assembly people, our representatives, and our senators. This is not going to, by itself, this does not change the law in Tennessee. What it says is the fence that was drawn around the assembly with regard to abortions, the people are making that fence a little bit wider so that some restraints can be put there. But it's up to the assembly to then go and fill that space up.
We'll
So,
have another
say that this passes in our legislature, it'll probably take them another 6 years or better if they pass any laws to even get this even in that direction, right?
If this passes in November, the earliest it could have an effective law would be sometime next spring or July. That would be if everybody was on board and immediately ran it through. And
Don't
that's
have to
not
go
coming.
before it twice before the legislature.
No. What I said going through twice is the actual getting the amendment
Oh, okay.
on the ballot. Okay, to pass a law, they can do that in a week,
Oh, okay.
once the legislature goes into session in January. But political reality and the folderol that goes on up there when you're passing a law, and I've done some lobbying and it's a mess, it's going to take probably more than one session. Okay, to get one.
If they do pass this, why can't they just simply reinstate the laws that have already been?
That would be passing a law to say that. A law that has been rejected is no longer on the books. In order to put a law on the books, you have to go through a legislative procedure. You have to legislate. And every step in legislation has to be started from scratch before we can get back to where we were. So you got to change the Constitution to enable them, and then you have to lobby or be active citizens to actually make it happen.
So basically, we're giving them permission, oh, I'm sorry.
First,
How do we control this renegade court from declaring this First Amendment, if passed, from being unconstitutional?
I'll get to Amendment 2 in a minute.
Okay.
We're giving them permission, is all we're doing if we pass it. Say, okay, you guys can now make laws that can put these restrictions on.
Yeah, somebody put the handcuffs on them, and we're taking the handcuffs off.
Yeah.
But there's still a fence there,
Yeah.
okay?
Yeah.
Got it? All right. Next, Amendment 2. And Amendment 2 is interesting. We were at a Tri-County Republican Women meeting just last Saturday. And Brian Kelsey, who is sponsoring 3 personally and advocating all the others, presented in favor of 2. And he is the first advocate of Amendment 2 to actually be honest about it that I have ever heard. He said, and I was all ready to refute his argument, but he came 3/4 on my side of the argument. He said that the way that judges are being selected in Tennessee at the top level right now is purely and incontrovertibly unconstitutional according to the state constitution. Because Article 6, Section 3 of the Constitution of Tennessee says that judges of the Supreme Court shall be elected by the qualified voters of the state. Those are the words. Those are not words you see in this proposal. They say what the section is going to be deleted and then what it's going to be replaced with, but not what they're taking away from you. And so what they're doing is they're coming out with little flyers and a logo that looks like this. And because you can't read it all together, it says, "Your voice, your vote on judges." It's because they're taking away your voice and your vote on judges. What happened in the 1970s is, I guess, the growing power of the Republican Party made the Democratic power brokers a little worried, and they came up with a scheme to stop judges from being elected and to get them appointed. And so they come up with a panel that makes recommendations to the governor appoints the judge he wants from that selection of the panel. Usually there's 3 people on a panel, and that person becomes a judge immediately on the Supreme Court or the appellate courts. At the end of the 2-year period maximum that person has been on the bench judging us, then there comes what they call a retention election, the next general election. Actually, it's a primary election. We had that one in August, which is an interesting selection of when you get to vote on them. It's the least attended election, usually. And it's not an election for the judge. An election, and I've got an 1823 dictionary to prove it, is a selection of one or more from a greater field. In other words, in a genuine election, there are multiple possibilities that you, as the citizens, get to choose among. So you're actually choosing who is going to be a judge. On a retention election, you're not choosing who's going to be a judge. You're simply exerting the power to get rid of one. The governor will replace that person's position. You have no say in who becomes a judge. You do have some say now in who gets rid of it. And that is the system they put up in the 1970s, as it is now in the 1990s. There were some changes made. You look up on Wikipedia, and it's called the Tennessee Plan. And there is nothing in the Constitution that authorizes it. And I think David has enjoyed the way I like to describe this thing. Imagine somebody carjacks you. Now they're driving around your car for a couple of years, and people are beginning to ask them, where'd you get that car? And now they're coming back to you and asking you to give them title? Right? That's what's happening here. Now, there are arguments that, an election for judges is just disgraceful, and, there's big money comes into the play, and it can be real corrupt. So you tell me, which do you think is more corrupt? An election where the issues and the names are out in public, even if there's big money against, behind some of them, and whether they lie or not, or a backroom deal? Which is more likely to be corrupt and undiscovered? Yeah, I think so.
How come the state attorney didn't inform the governor back then that they were violating the state constitution then?
Here's what happened.
In the back room.
It has been challenged. It's been challenged 3 times, and it goes all the way up through the judicial system, and it goes to the Supreme Court. And the Supreme Court said, "Well, wow, we are the ones who can benefit or lose from this, so we must recuse ourselves." All right? And so somebody appoints a special panel of attorneys to be the Supreme Court, and it went in front of them, and they said, well, a retention election is an election, which of course it's not, but it has been declared constitutional 3 times by the Supreme Court, at least the substitute Supreme Court, which, by the way, was appointed people, not elected people. This is stacked against us, and it is hypocritical, and it is wrong to do it. Now, again, there can maybe be some argument that an election, and nobody knows who the judges are and stuff. That was one of the arguments I heard just recently. And maybe we don't know the names of our Supreme Court judges because we didn't have to elect them.
They were out there for us to know.
I discovered just the other day, I found among some papers I was sorting out, it came in the newspaper, or I picked it up somewhere, but it was from the commission, but it was recommendations on all of these judges, supposedly based on review of their performance. And got by this, what is it, a 9-member commission? Apparently the commission that probably appointed them in the first place.
Yeah.
And all the recommendations, there were 2 of the judges that they recommended that they not retain. All the others were pretty much 9-0 or 7-2, recommend to retain. And they allowed the judges to respond, and I thought the one that, this McMullen or whatever her name is, had responded very well. She was the one that they recommended, that they taught that, you know, you not retain. But she gave the best response in responding to their criticism of her, of, you know, anybody you could think of. So anyway, I didn't find this till after the election, but apparently they did put out this report that was available to the public before the election, but who knew?
Yeah, and the thing that's fascinating to me is they're so willing to say your voice, your vote on judges, instead of saying, let us be in charge of who your judges become. Why would they mislead like that if there wasn't something in it for them? The minute somebody does something like this makes me think, this is not good for me. As a citizen, this is not the way I want things run, dishonestly. And who are the people sponsoring all the ads now you see for Yes on 2? Trial lawyers, big business, past governing officials and current ones. Why? Because they're the ones who will be choosing the judges.
I'm sure it has to do with money.
You know what gets me is on the ballot, the way they word things, where it makes it very confusing on the ballot. So once you even know when you get in there, if you read it, you say, wait a second, this is not what, you know, you're hearing beforehand.
Yeah.
They don't put it in plain English, this is gonna be this or that.
Correct.
Yeah.
So,
It's intentional.
what we have here, I think, is an attempt to take power away from the people. Yes, elections are messy. I'd rather have it that way than a backroom deal. And the dishonesty of the approach makes me vomit. All right? I think it's just very dishonest. And it reflects badly on the people who take that side. All right, then we get to Amendment 3. Amendment 3, how many of you remember, I think it was around 2001, something like that, when all of a sudden, out of the blue, there's a bunch of turmoil in Nashville, and it comes out that, gosh, somebody was bringing up, John Wilder and somebody else, a motion to install an income tax in the state.
Sunquist was pushing it.
Sunquist was pushing it, and who came out and said, hey, activists, you know, called a bunch of people she knew, they're trying to pass an income tax in Tennessee right now. I mean, just, you know, one of these steamroller backroom deal type of things. And all of a sudden there were cars driving around the Capitol honking, and then things got a little out of control, and a brick went through one window and stuff like that. And the legislature got the idea that at that point in time, it wasn't a very good idea to pass an income tax in Tennessee. But the people who want an income tax are still up there. And it is possible, although the Supreme Court has said, well, you can't have an income tax, certain conditions. We want no income tax, period. And the only way to stop the assembly is, you know, in one, we want to expand that fence that's around the assembly a little bit so they can be a little prudent rules going on in abortion. When it comes to income tax, we want to make that fence real tight and strangle them. All right? We are the owners of the Constitution, and that's the form we want for it if we win. No constitution, no statute will be possible within the Constitution that creates a tax based on our income or on the payroll, which would be the employer paying the equivalent of our income tax. We don't want that in Tennessee. I like to add one other thing about the income tax overall. You know, it was passed in 1913, the federal income tax. And to me, rather than the amount of money that they get, the shocking thing that they accomplished by doing the 16th Amendment was before that, in order to look at your personal financial papers, the way you handled your money and so on, they had to get a warrant based on probable cause. And now, as of the 16th Amendment, you have to search your own financial records, often create ones you otherwise wouldn't create, And then you have to report them to the government. So they get to see what you're doing with your finances. They get to make rules that favor some activities and disfavor other ones. They have increased the control that our forefathers saw was evil by skirting the Fourth Amendment against unreasonable searches, by making you do your own search and reporting it to the government. And they have been managing us for 100 years that way. We don't need that added surveillance in Tennessee, I think.
With all the corruption going on with the IRS, do you think they'll eliminate it?
You know the question
There
really,
isn't anybody there to.
will they eliminate it or should we eliminate it?
Well, I wish we could.
We have to get a whole lot more people active, but I think that's something, there will always have to be a service that collects revenue.
Right.
But the income tax part of it, no. And I would also say that we should abolish the bureaucracy that currently is the IRS. Because we have a culture, an establishment, a fourth branch of government in Washington that has grown up and survived on making rules outside the legislative process, regulations. And this whole monster that's up there, I think, needs to be fired, and you know, in a phased and prudent way. We need to build a different bureaucracy that's much smaller. Our freedoms have been crushed by what's there. The 16th Amendment is a substantial part of it. We don't want to keep that kind of thing growing in the state of Tennessee.
A flat tax would eliminate that.
Pardon?
A flat tax would eliminate
Flat tax would be helpful, absolutely. And frankly, I'm for a sales tax and not a flat tax. That way, every transaction, you get to choose whether or not you're going to pay a tax because you choose whether or not to make the purchase. It would be frighteningly high tax considering what the sales tax is now, but the process for collecting it already exists. And if your taxes aren't taken out of your income first, you're going to have more to spend on the products and the tax you choose to make. So that's yes on 3. The final one, Amendment 4, is interesting because what has happened, forget what year it was, 2002, something like that, we, the Assembly, passed a, change to the Constitution actually, that enabled us to have a lottery, and in this case, gambling for charitable organizations. 501c3. Okay, that's the general classification for lotteries as defined, for charities as defined in the tax code. What Amendment 4 is designed to do is to add one more category to that. And instead of just charitable organizations, 501c19s are specifically veteran-oriented organizations, like the Marine Corps League, Veterans of Foreign Wars, that sort of thing. Non-profit, but for veterans specifically. And allow them to have one fundraising a year that's based on some sort of game of chance. Now, another interesting thing that happens in that, the way the Constitution is written now, 501c3 is defined as the way the code was in 2000 or subsequent amendments to the federal regulations. And I'm not sure why they did this, but when they drafted the one that we're looking at now, the 501c3s and 501c19s as defined in the tax code in the year 2000 without any updates. Now that could lead to a bunch of confusion, because if the tax code changes and somebody says, oh goody, I'm a 501c3, but it's under the 2014 rules, and it wasn't there in the 2000 rules, you may have been a 501c3, but you're not in compliance with the Tennessee regulation that permits gambling, and you could get in trouble that way. Other than that, I basically think that if we're going to have gambling in the first place, veteran organizations are like other charitable organizations, and I'm going to support this particular one. I'm less fervent about this. I'm yes, no, yes, yes, But the last one is if instead of yes. Okay?